Here he comes right now. Culprit! Is it true you refuse to swear to tell the truth, the whole truth, and nothing but the truth with your hands on the Holy Bible?
Yeah, that's right. I refuse to swear to tell the truth and the whole truth with my hands on the Bible because I've read that Bible myself, and you should read that Bible instead of swearing on it all the time. Open it up to Matthew chapter 5, verses 33 through 37, which specifically end with the verses say yes, yes, or no, no. Anything else is of evil. Next question.
Avenger, what's all this about freedom of speech?
Yeah, freedom of speech. Well, the powers that think they would have us believe that they give or protect our freedom of speech, when in fact it is the supreme designer, and only the supreme designer, who gave you a mind and a mouth, who can give you the freedom of speech. Any other concept is ludicrous. It is a sacred gift to be used with reverence.
Order in the court!
Consult your creator, not your government.
I said order in the court! Corporate Avenger, I'm citing you for contempt of court!
Well, now you finally got something right, Your Honor, because I ain't got nothing but contempt for your courts.
It's all such a web of lies. Attorneys all sliders and we all flies. It's all such a web of lies. Attorneys all spiders and we all flies. They love to drag your ass to court. This is the arena for their sick sport. They run for office and make more laws. 100,000 reasons to further their cause. We get charged, so we better watch out. In a system of fear, where they make out. Either way it goes, good or bad, the attorneys get paid and they get fat. Is there justice in a world gone crazy, where it's survival of the fat and lazy? Lazy, 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 it's all such a web of lies. Attorneys are spiders, we are flies. It's all such a web of lies. Attorneys are spiders, we are flies.
Order in the court! Order in the court! Order in the court! I said order in the court!
One to prosecute, one to defend, one to judge you, and in the end 12 of your peers are forced to sit in as lawyers lie so they can win.
Hi everyone, good morning. I'm here, stand by. I'm just getting warmed up. This is Corporate Avengers, dedicated to my sincere fallen warrior.
I can't remember when I was free. Free to worship, free to speak. They never practice what they preach. The less you've got, they've got you on your knees. You'll come please, they get fees.
Welcome to the Court of Justice, the window to the truth.
Attorneys are spiders, we are flies.
Host, Amelia Duran. It is January 23rd, 2018. And I'm getting ready here. 1 second.
Such a web of lies. Attorneys are spiders, we are flies. It's all such a web of lies. Attorneys are spiders, we are flies. It's all such a web of lies. Attorneys are spiders, we are flies.
I have a great show planned. I am having guest Chris Hallet on this morning. And he's going to be talking about his emoluments clause. And then I have Ms. Lotus Justice, who's also coming on. So this is going to be a really interesting conversation because both of these individuals are seasoned warriors in the court. And can't wait. So let me go ahead and get started. Let's see if I can get Ms. Lotus this morning. Here we go. Stand by. Okay. Lotus? Which account are we on? Are we on Big Bertha or are you there? Are you listening? I'm trying to call you. All right, let's see if I can get Chris on the line with us. Somebody here.
Hello?
Hi, Chris. Good morning.
Hey, good morning.
Welcome to the Porthole to Justice.
Good to be here. Good to be here. Pardon me, I'm just finishing up, putting some thoughts down on paper real fast before I forgot.
Oh, okay. Well, we are actually live right now.
Then everybody will be shocked that I was busy working.
Thank you so much for coming on my show. I'm standing by for Lotus. She's going to join us here in a few. I was just wondering if you could share with everybody a little bit about your emoluments clause and what it means.
Well, basically, like everybody else, I went through a real bad situation. In my case, it was a divorce and a silver bullet and all that. I won't go into the details because that's just another story that nobody wants to hear anyway. So, but anyway, the long and the short of it is, I knew the answers were written in law somewhere. So, doing what I do, which is loss prevention for corporations for years, I said, okay, well, this has generated a loss. How would loss prevention handle it? So start from the beginning. And that's what I did. Well, when I was reading the Constitution, I literally tripped over the word emolument. Now, the word itself just means any advantage, profit, or gain received as a result of one's employment or holding of office, which means anything that happens in government, whether it's money, whether it's favors, whether it's a position of authority, all of those things are called an emolument, every bit of it.
Mm-hmm.
So,
this is Lotus. I'm sorry.
There she is.
Hi, hello, Miss Lotus Justice. Good morning.
Hello. I'm sorry. I was waiting for you to call me. My bad.
Oh, that's okay. No, we just went ahead. I interrupted Chris, so let me just let him finish his introduction, and then
I would like to hear this.
Yeah. Okay. Go ahead, Chris.
Okay. So, anyway, when I found out that this word had never been spoken in court in 230 years, I said, okay, let's work this backwards. So I constructed any advantage, profit, or gain that was received by the actors who happen to be in positions of authority and said, is this basically a wise way to be spending the people's money? I mean, let's call this spade a spade because every one of them was enriched by it. And the first words out of the other side's mouth is, oh, that's RICO. I said, no, that's not RICO. RICO's the process. I'm talking about the thing at the end, the emolument itself. And that was the thing that the court needed to hear. Because for all these years, every one of these attorneys, they figured out how many different methods to rebut their principles and their practices, right, their process. Mm-hmm. But they purposefully avoided the word. And the word is the emolument at the end. So when you talk about what's the crime, okay, well, the crime of unjust enrichment directly relates to their holding in position in government, which constitutes an emolument. That's something they can't do because it has nothing to do with the establishment, support, or management of government. That's a trespass. And the federal court said, in my Utah case, they just recently came out with a decision, said, you know what, you're right. Here's what you got to do. You have to go through and make Congress decide what's a just and what's an unjust enrichment and then come back to us. That's what they said. So,
they already did define that under the TONA.
What's that?
They already did define one of those under the the lawfully passed Titles of Nobility Act of 1810. They, by a common law declaration, defined accepting of a title of nobility as an emolument, which nullifies every attorney and doctor and accountant to have positions of power, trust, or authority within the republic government, have any power of authority to change our laws. And they are barred from law and law of equity by that. So they already have defined that unjust enrichment, and one of them is the acceptance of a title of nobility. That's why they hid it, so that they could.
Well, exactly. And we said, you know what? Nobody's ever questioned it. So the court said, go question that. Because that's a usurpation.
Also not only have they never questioned it, they've never brought the facts of law to the bar, because that is what attorneys at law are tasked to do. As the principal job is to prevent the presentment of facts or law upon the record. They do that by never affecting proper Rule 11 in civil procedure tells you that they never affect proper affidavits.
Right.
When you are in court, actually it's not a court; it's a simulation of process. It's not a true court; it's actually a bank hearing. But they never take they never take testimony under penalty of perjury by the laws, which are required by 28-17-23, I think, which defines how people are supposed to be sworn onto the record in these forums. So it's all a simulation of process, which is a overt and blatant constructive fraud against the American people and our estates and chattels, which we are the creditors and beneficiaries of by all aspects of the trust law itself. Most people don't understand that a trust was created in 1810 by the Treaty of Peace and Amity, because under the feudal law, when we declared ourselves exempt from the civil authority, because what the TONA does is the emoluments clause are brought forth 2 times in the instruments of our formation of our government. However, there was no penalty for such acceptance of emoluments. The Title of Nobility Amendment, the first 13th, there's 3 of them total, but the first 13th Titles of Nobility Amendment gave that penalty. It was a loss of citizenship in the Republic and the loss of the ability to hold positions of power or trust. So it is an enforceable law at that time.
Yeah.
And when we did that, because you have to have a penalty. You can't have a statute without a penalty. That's an unenforceable statute. You can't have a law without a penalty for the trespass or the tort of it, or else that's not enforceable. That is a construct of law. So the TONA set the penalty for emolument: a loss of citizenship and a loss of the ability to hold positions of power or trust within the government, the law government, the de jure government. That is why we're de facto, because we have attorneys operating and controlling in unlawful monopolistic fashion through the bar unions of the the corporations that overlay the territorial republic states. They are oppressing a monopoly of foreign law upon the American people. And it's a form of foreign law that by the declaration of the TONA under feudal law, we are exempt. It basically required us. It's actually a premise in feudal laws of England. And there's a maxim for it, but basically it translates that he who becomes a soldier of Christ has ceased to be a soldier of the world, nor is he entitled to any reward who acknowledges no duty. So we basically, in the declaration of the TONA, made the United States of America a civilly mortis dead instrument that was placed into an estate and trust. And the Titles of Nobility Amendment is what required that to happen. We were then required by the feudal laws of the time to place all of our estates into the hands of the law of the realm, the prevailing law of the realm, which would have been the Pope, the papacy, and the very instruments of civil law that we just removed ourselves from. So we declared ourselves exempt from those civil administrators, and were required, after a war, the War of 1812, to put our estates and to declare our estates. And we did declare those estates. We declared a plenipotentiary, which is a surety. So in the Treaty of Peace and Amity of 1814, we declared our plenipotentiary to be little c citizens of the United States. Well, this was turned around to be this United States citizen in the 14th Amendment. So your 14th Amendment is assessed to KV. It is the object, it is a trust surety. It's a plenipotentiary in the estate of the United States of America that was set aside in 1810. Well, the attorneys and the Pope didn't like the fact that they could not oppress their form of civil law upon us, and we're basically exempt from the power of the civil magistrate by having set our estates aside, the plenipotentiary citizens of the United States and or United States citizens. And what they've done to circumvent this common law act, which is recognized under the feudal laws of the time, was to then put our children into contract by putting the soul plate. It's called a soul plate, when they put that foot upon the certificate of live birth. Well, what that does is it contract unlawfully. This is an unlawful act in the law of equity. It puts that child in contract with the estate managers, and it interferes with their fee simple plenum dominum under what's called lineal consanguinity, meaning the inheritance from father to son to child to child. So when the rules of plenum dominium require that you put your foot upon the land, okay, in order to achieve cession, which is the proper right to that land. What they do is they put your child in contract with these foreign agents for the crown, who then basically emeritize your child and make it a commodity. And these are all criminal acts under the law that they are under. It's a criminal act under feudal law. It's a criminal act under canon law. It's a feudal act under our crown of law. So what most people don't understand is that we actually created our own crown of law, the fourth crown of law of the fourth branch of our government, which is the people have the law above the kings and queens and popes and Caesars and whoever else are the false Elohims that presume to be our judges when we aver and assert that we only have one judge, and that is in the creator of all things. So we removed ourselves from their civil jurisdiction in 1810, and they have cooed this existence for the purposes of stealing the land and to subject the people back into the civil magisterial constructs by acts of constructive fraud. So in your case, you already have. I mean, if we were probably to join my knowledge of the law and what we've been moving forward in our case with your declaration, the unjust enrichment has already been defined by the law.
Right, 3571, $250,000 for each occurrence of violation of oath of office. I mean, that's just one example.
That's a small amount, because under the law of equity, they're required to surrender. Okay, if you go and you look into the foreign state, the Title 28, Chapter 97, which deals with acts against foreign states. By law, we are all foreign states to the prevailing jurisdictions of any civil authority, any civil magistrate. We are foreign to them. We have foreign sovereign immunity by our declaration of 1810 of the 13th Tona. They are not supposed to be trying to oppress civil authority, Roman civil law upon the American people. We are supposed to be left alone. They've been allowed to manage our states in shadows. You can prove by various instruments in Congress, the annals of Congress, that they had contemplatively raided and defrauded those instruments for the purposes of trying to collapse the trust itself by devaluing it. In trust law, if you can devalue an estate to like 3% of its total value, they can collapse it and dissolve it and say it's all theirs, right? That's what they've been trying to do. But the American people are so brilliant. We have, I imagine that all of our inventors have saved us, and that's why they seize inventions to try to keep them from having an actual value. A lot of our patents have been unlawfully seized, things like that, because that's part of our estate. So they've been trying to basically defraud and steal, route the substance of the American people, as is declared in the Declaration of Independence, in order to undo the declaration of us being exempt from the civil magistrate in 1810. So the whole purpose of the obfuscation of the Titles of Nobility Amendment passing lawfully, which it did, I've proved that by state papers, and those are on the record, have been on the records of cases since 2012 at least. They've been noticed. There's no argument against it. The Virginia papers prove that it was passed by even a second witness. So it's been passed. It's a lawful existence. We declared our state, and we were supposed to be left alone. They didn't do that, because the Pope wanted to be the vicar of Christ, and in the Declaration of the Tona, we basically said, you're not our vicar, and so it's basically the contrived coup to oppress Babylonian slave trade of the cult of Rome on the American people, despite our proper declarations in law, feudal law, Roman civil law, ecclesiastic law, and to hide the fact that we have our own crown of law, that we are exempt from their civil processes. We are the foreign sovereign, and they have no jurisdiction over us. We are only bound by our common law. And the nexus of where they do have control are in the Cesta KV estates, the 14th Amendment citizens, which are basically corporations. So what our founding fathers did is they declared our plenipotentiaries to be any corporate estate, like any corporate body of the states of men, which are all the states of X. The United States Corporation Company is a public. It's a corporate charter, a franchise of a public nature. It, however, is registered as a foreign corporation. So the states of X, which are run and monopolized by the bar unions, they are fictions of the bar unions, have created a liaison with foreign agents in these franchises, the United States Corporation Company, which are registered as transferring utilities with the United States, and they are able to transfer our wealth out of our country, including our children, hidden as just instruments of trust. So they're using our children, the instruments against our children. There's particular exemption in Chapter 97, which is cross-referenced to Section 1332C, which is if you study Roman law, discloses the fictio, a fictio. And a fictio in Roman law is when there's a presumption or supposition that's averred by the plaintiff that the defendant cannot overcome, such as that the defendant is a Roman citizen when in fact they are not. In 1332C, they put every infant with a legal representative. And that infant and the legal representative are presumed to have the same citizenship. So they make all of your children citizens of Rome by the fraudulent constructive fraud in Title 28, 1332C. So they've circumvented the common feudal law declaration of 1810, one, by hiding the fact that it was passed, that the penalty for emoluments were defined as a loss of citizenship within our republic. They've hidden that, and then they've circumvented that knowledge. You can tell that they would have no need to create such obfuscations and to statutize a fictio in Roman civil law within 1332C and forcibly engage children in contract with the Roman agents, the esquires, which is against.
And also now, to that point, if I can interject something real quick. We just got a decision out of, I believe it was Arkansas Supreme Court, said that the Arkansas Congress can no longer pass legislation that is repugnant to our form of government. That is significant. And the thing that makes it significant is the inherited emolument known as family law is repugnant to our form of government. So in context of what you're talking about, let's just take the United States of America Corporation, for example. Every corporation has what's called a loss prevention department. You pick up the phone and call Target or Walmart and ask for loss prevention, you're going to get a person. Okay? The United States of America Corporation did not have a loss prevention department until I claimed that emolument here in Florida and said, here's how we handle these things in loss prevention. Here's our corporation's core principles or maxims of law. Okay? And based on those core principles,
repository trust law. That's what it's a repository trust law requirement that they fulfill their fiduciary duties. And the fiduciary duty is to preserve the rights of that which they are the fiduciary of, which is the creditor and beneficiary of the trust, which is the American people.
Right, and that here's some reason I constructed my case the way I did. I am the loss prevention department for the Corporation of the United States of America. I represent the Corporation of the United States of America in the best interest of my children under the doctrine of parents patriae because I am their father. Right?
Right. You have a fiduciary duty as the holder of the surety. The difference between a surety and a fiduciary is a surety, the holder of the surety, the plenipotentiary. You are the holder of the instrument of sustake that they unlawfully created for us against the law of equity at the incarnation of when we incarnated into this realm. They put our feet on a document and engaged us unlawfully in violation of all fraud. I mean, it's a violation. It's considered a constructive fraud by the law of equity to engage a child in contract. It's considered a constructive
That's an unlawful transaction. It amounts to corporate espionage. That's what it boils down to.
You have a fiduciary duty as the holder of the surety because that sustake instrument was created in the name of you. So it is clearly created to be, you are declared by its creation to be its beneficiary and creditor under bankruptcy, under the Bankruptcy Act of 1898 actually is where priority creditors are declared, which was after the Civil War. So you are the priority creditor and beneficiary of that sustake v. The 14th Amendment United States citizen as the plenipotentiary that was declared in the Treaty of Peace and Amity in 1810 when we removed ourselves from the prevailing law of the realm, the Babylonian slave trade with the vicar of Christ being the Pope. Okay? We removed ourselves from that. You have a duty as the holder of the surety to protect that instrument from being defrauded. And what is happening when we are doing that, because we are learned in the law, which they're not required to be under Title 28. The attorneys are not required to be learned in the law pursuant to Title 28. We are learned in the law. When we, as people learn the law, come into these forms of bankruptcy settlements, which is all they are, because they're affecting maritime liens. They're affecting maritime liens and admiralty suits to seize the instruments of foreign states under auspices of constructive fraud. Under Chapter 97, that is a crime. That is a crime. By their own
which is human trafficking, right? And that's the reason that President Trump just declared that there ain't no more human trafficking. That's done. So put it out of your head.
And that's how you cure the trust. See, our job, anything that has happened this far in my mind, and I'm not trying, because I'm as guilty as everybody else, is the people learned in the law, the American people, because we have been miseducated as to our history and our rights and our duties as the holders of sureties. To keep these fiduciary agents in compliance with the law, and in most cases, we're oppressed. I mean, we're tyrannized. I was put in prison for a year for affecting my rights, and protecting fraudulent claims against my instrument. So they tyrannize us. Under the same instruments, these magisterial civil forms that we by law are exempt from. We are not under the law, under their jurisdiction by the declaration of the Tona, which is why it was so significant for them to obfuscate that and hide its lawful passage, because it exposed the entirety of the constructive fraud against the United States of America by these foreign agents for the crown and the Prince Electorate of the Holy Roman Empire, the England, and all the other four beasts from the Treaty of Verona. It has hidden our lawful rights to be exempt. They have jurisdiction over the corporate charters as 14th citizens of the United States citizens, are not flesh and blood instruments. They are fictions of law. They are Susta KV instruments. They are instruments of trust. The attorneys, you to declare yourself a thing and bring actions of in rem and quasi rem against us as adults and as children, which is a crime. You cannot. It is a crime to treat a child as a thing. Okay, it is a crime. And so they are bringing these causes in CPS courts that are merely civil forfeitures. These are in personam acts where they're acting like they're treating you. They're in personam. They're under the auspices, the actions. They're simulating the process of an in personam proceeding when it's a quasi-rem proceeding where they're attaching the child as an auxiliary maritime instrument. Well, here's the law in admiralty law, which is what they're in. In admiralty law, within the states are barred from in rem actions. Okay, they cannot bring in rem actions. It's against the law. When they bring in rem actions, when they're operating in rem in a situation where it should be in personam, and the savings to suitors clause of the instruments of the origins of the Judiciary Act. This is declared in the Judiciary Act of 1789. Which created all the statutory courts that are now operating unlawfully, encroaching upon the land and repugnant maritime claims. When they do that, the law of admiralty says that the common law shall rule the decision. Well, they're sitting there trying to say we don't have common law. Well, guess what? When you have diversified claims with foreign states, even Title 28 and the prevailing law, their law, says that the federal common law is the rule. So in all these cases that we're bringing, people are sitting here basically averring the right stuff. They're saying, I'm not subject to your jurisdiction. They're demurring to their jurisdiction. They can't prove the demurs. You're saying that I'm not subject to you because you're able to have affected emoluments. You take what you've got and you go, oh, yeah, we already did prove this. Here's your enrichment. You took an emolument. You took a title of nobility. You're no longer a citizen of this country and you're foreign to us. That's a fact of law. And that's a fact of law that has been obscured to some attorneys. It's definitely been obscured to a lot of the people of the United States. But there are some people who do know it and are effecting an unlawful coup within the instruments of state and have been doing that for years. They have unknowingly been violating trust law. And what this does is it allows the American people to lay claims against Britain and the Pope and all the esquires for the bar and the instruments in coup in the United States that have been couped since the Civil War, actually couped since 1810, and demand reparations under trust law with compensatory and punitive. And there's a reason why we're an offset to the Federal Reserve. So, your case is already you're able to prove that what they're wanting you to do is to allow the attorneys to define unjust enrichment when we've already defined under the common law what one form of unjust enrichment is and its particular form of emolument is, and that would throw all of them right back into the foreign within their own construct. But they're in kind of a paradox. And so
and that's what loss prevention does. Right, and here's the reason I presented the negative nexus the way I did. Because we're taking all these bad actions, right, this negative evidence, right, we're factoring out the fiduciary responsibility of the attorney, right? That's principles of higher mathematics and calculus, and I'm qualified to do that under my license. And the court agreed. They said, you're absolutely correct, you are qualified. Congress wrote it in law. So when I had torn out the negative context of the attorney and their bad presentation and proved that to the court, that showed the court the negative. So in essence, the only one who's ever been able to prove a negative is me. And all it took was the basic, our basic fundamental principles of law, which are generally maxims of law. Well, one of our maxims of law says, a negative destroys a negative. So how do we get rid of that bad evidence or that branding on your, here's your oath of office, go to work. And that's exactly
well, and here's the whole point of the fraud that everyone walks into in these simulations of process. That plaintiff, as a corporate instrument or an attorney, has no standing in the law to attach your estate. And that's the point. It's a fraudulent action in its presentment, because the only person you should be dealing with is the trustee, which is the administrator of the hearing, which is the dude up on that bench as a magi, the civil magistrate. Now, what happens in their constructive fraud is what's called parole evidence. Parole evidence is a type of evidence that is described in the law of equity, such as when you go into someone's, when someone's dying, and one person is allowed to walk into a room and alone with the dead person, and boom, the guy dies, and you come out and say, hey, his last words were, I get everything. Under the law of equity, and this is why you would never allow someone alone when they're dying, because this is allowed under the law of equity. It's an unchallengeable presumption that this person is the defined executor. So they use it in their fraudulent constructs in these forums, because when they go, hey, do you want legal representation? When you go into a room alone, or when you go and talk to the parole, the pre-sentencing person, the parole agent, get it? Parole, and by the way, parole is also a military term. But when you go and you have a secret meeting with this legal representative you took at the behest of the trustee, that legal representative conspires against you and cooperates with this plaintiff over here, who's also in his bar union, and they actually are able to convert under law of equity by bringing forth parole evidence that you declared yourself basically incompetent in your own affairs. The new executor becomes that plaintiff. So they are actually defrauding you of even your executorship in these false actions. So, the fraud of this simulation of process that these esquires for the bar union have put upon the American people are egregious. They're repugnant. They're acts of constructive fraud. It can be proven that they're acts of constructive fraud by existing law. And you wouldn't understand the context of everything outside of the actual lawful passage of the titles of nobility, which defined what an unjust, the only one we cared about. The only one the United States of America as a republic cared about defining was the acceptance of titles of nobility, because we knew that people who take on titles of nobility, they are sophists. They act not on the interest of us. They have more than one master. They do not serve the creator. They do not serve the law. They serve their own personal lucre. They save their own personal interests. They serve the interests of the masters that...
Uh-oh.
Yeah.
Okay. We temporarily lost Lotus. Oh, she's back.
No, I'm back, yeah.
Okay.
These people, I don't know, it does that every once in a while, it drops me. These people are openly defrauding the American people by these quote, what they call courts. They are not courts. They are actions of
That is an inherited emolument, which is repugnant to our form of government. And that's exactly what I've come forward and said through my principles and practices of loss prevention. And even Congress is saying, yes, that's true. I've got backing from the federal courts now that are saying, yes, that's true. That's repugnant.
Well, they've been denied this knowledge as well. But there is a select group of people that are, and that's this cabal we're going to find about. There is a functional cabal of foreign agents who have every bit of knowledge as to what they're doing, the crimes they're effecting against humanity, the crimes they've been effecting against the American people for almost 200 years now. They are knowing. It is a contrived, constructive fraud. The existence of a secret treaty existing between the esquires of the bar union and the Pope directly to undermine our Republican form of government was exposed in annals of Congress. These are long-standing coups that have infiltrated, and it's showing with Trump, and you have 6 agencies. You know how those 6 agencies were interconnected? By the bar union. Every one of those principal actors, I assure you, are esquires of the bar union. And they are operating in concert and in acts of sedition and treason to undermine the republic, to undermine the laws of the United States, the laws that their own their good bar union members actually put forth. I mean, in this case I'm in, we have bar union members saying that these states are exempt from the mandates of the contracts through Title IV, which covers CPS seizures with grandparents and in criminal offenses, quote unquote, the Title IV D and E. They're trying to say that the states are exempt from the mandates of the contracts that they enacted, but we're going to still pay them. When you show that they blatantly are operating in RICO to kidnap and traffic children, you've got the bar union members covering up their crimes by basically committing acts of constructive fraud and treason themselves by saying that they're exempt from their contractual obligations. No, they're not. No, they're not. That's a violation of the law of equity. So these attorneys and these magi in these Pharisees' robes sitting on these civil forum benches, they are mandated by their instrument to follow the law by their ens legis instrument. When those judges step outside of those ens legis mandates and try to affect these coups, they are crimes, they are torts, they are treasonous offenses, they should be treated as such. And when you have a state of them, such as the state of Ohio, who has operated in concert to in conspiracy against substantial rights to kidnap a child and perpetuate and allow the continued kidnapping of a child by their own acts in the Congress under the 13th Amendment and the 14th Amendment, those instruments of public franchises, corporate franchises of a public nature, should be seized and brought back into the Republic and taken out of the control of those foreign cooing agents. That's how you correct the course of the law. You prove the constructive fraud in these monopolistic.
I have a question, and I don't mean to interrupt, but so with with Chris's emollients clause and Donald Trump's new executive order, how can we implement this to?
Well, all you have to do is show acts of constructive fraud, and that's
exactly what we're doing. And I'm using ironically. The principles and practices of loss prevention are exactly the same principles and practices that are written in
I'm sorry,
law,
I can't hear him there,
right?
Amelia.
So the corporation, by default, the people have created their own defense mechanism and never realized it.
Can you hear?
Absolutely. It's a paradox. It's the snake eating its own tail. And that's the manifest destiny. That's our manifest destiny, is to remove these false Elohims that surreptitiously through coup and acts of criminality and crimes against humanity have undermined all the Republican forms of government thus far, so that the Pope can remain the vicar of Christ's trust. And this is the beauty of the American construct. We are founded upon the tenets that Yeshua affected in his own trial, that we are not subject to. He was the first person in my recollection that has historically declared himself civilly dead. And in my mind, all of the civilly dead constructs derive from his declaration that Rome nor the Pharisees were his master or his ruler or his judge. When he did that and they killed the guy, that was a crime. He declared himself exempt from their realm, from their law, and their answer was to kill him. Well, there was a trust affected upon that. It's the trust of the 30 silver pieces put into the field of blood that the Pharisees could not put back into the coffers of the treasury because it was blood money. It was blood derived from the blood of the innocent man. So the trust law that we're running on was established by Yeshua. That's why the Pope had to take control over that estate. So the Pope, as the vicar of Christ in the Vatican, because Constantine's the one that used the words law of the land, So they basically usurped the Roman Empire through fraudulent claims and became the vicars of the Holy Roman Empire, right? And the trust of Christ. So this Vicar of Christ Jubilee Trust is being run by people who don't even believe in what he said. And they had to do that to try to maintain power and control over all their vassals. And that is the secret Treaty of Verona, where the four Prussia, Russia, I can name them all, but the four beasts in the Bible conspired to prevent any form of Republican government from ever coming to power that would rival Rome, because Rome wants to be the rulers of all of us as vassals, and that the Caesar is the man of the world, the King of Kings, the Pope is the Vicar of Christ. And so what you have is you basically have America exposing and being able to prove this 2,000-year-old plot to affect totalitarian vassaldom upon all the people of the world by this cult of Rome. And they're going to get found out. And you're starting to see the veil cracking with what has happened with the Clinton Foundation. And I'm going to tell you, they were baby trafficking. The FBI should have no authority in this investigation, because we have evidence that the FBI has been actively participating in the trafficking of babies across international borders up to 25 years ago. These people, the FBI, is just embedded with people who have knowingly violated the law, that target people who try to bring the law to. The FBI is the worst agency when it comes to harassing people like me and you, who know the law and bring the law. These FISA warrants and stuff, I promise you that some people that have been bringing causes against these unlawful bar union monopolies, which are in violation of Sherman Antitrust Act, the Hobbs Act, they're in violation of a lot of acts that are already there. We've been targeted. And so you have a conspiracy to undermine even people bringing lawful claims as the holders of these sureties. And that's a crime too. And they were egregious under the law. They're egregious and repugnant under the Constitution, and under both pillars, the de jure Constitution and the de facto Constitution. The de facto Constitution is a statutory instrument. Those statutory agents that have taken an oath to that Constitution are not even abiding by those laws. They're not enforcing the statutes that the de facto, the Congress, not a Congress assembled, but the Congress has brought forth as the law. They are allowing judges in these lower forms to basically openly and willfully kidnap babies in violation of those federal statutes. The bar unions of the states are imposing immunity, saying that when these judges...
Well, okay.
Did it drop you again?
Lotus, yeah, you're back. I want to hear what Chris has to say.
Yes.
And how we can use the emollients clause in your case, or in many of these cases where the courts are basically exercising procedure over the law.
Well, they're not even doing that. They're exercising basically crimes.
Can Chris?
Yeah.
I'm sorry.
Yeah. No, go ahead.
Exactly, and everything that Lotus said is exactly 100% true. And the way we handle that is we say, okay, look, these things did happen. It is what it is. Can't change it. Can't unring the bell. Here's what we can do from this moment forward. Okay, we're going to do what the American people have designated, and the American people will see. We understand everybody who goes and punches a time clock works for a corporation, knows and understands what the principles and practices of that corporation are, right? They follow that process repetitively over and over and over and over and over again. So, basically what I've said, and so far, even the federal courts seem to be in agreements with it, is these multiple usurpations based on these repugnant acts, they've got to go. I mean, we're right back where we started. To when we declared independence, we declared independence from all this crap. And, because of the false construction and the repugnancy of these acts, take, for instance, the best interest doctrine, the Rooker-Feldman doctrine, et cetera, et cetera. Those things can't even be brought into being or made effectual because they're repugnant. So, I mean, it is what it is. Because
and we need to correct it. We need to correct it because if we don't, the general and national government will lose all of its authority.
Emolument, period. On its face.
Well, I mean, and you also have attorneys, you have these judges who have interest in drug rehab programs. They actually are the owners. You have judges in juvenile court that are the owners of these foster care programs that states are paying. These are acts repugnant to the law. They're in violation of law. The reason why they're not being forced is because of the coup within the judiciary, and the judiciary is run by foreign agents who aren't even allowed to have the power to even affect our law. See, that's the purpose of the obfuscation, is for the American people to believe that these foreign agent esquires have any authority to define something that is legal that is unlawful. They don't have that power. They don't have the power to overwrite the common law. The purpose of the coup has been to obfuscate that the common law was made a crown of law. It is the same crown of law as the monarchical law under Chancery, the British common law. It has the power of the crown of the law of ecclesiastic law in the canon laws, and it is the power of the crown of the Roman civil law. American common law is a crown of law that they cannot traverse. They are barred from it. That is why they have brought the civil forum to the Bar of Equity, which they disclosed in their last Civil Procedures book, 2017. The first table has the maxims of equity on the left, and then the civil they call it the rules of equity. They like to undermine the word maxim. It's so bad. A maxim is not movable. They want to call it a rule so that they want to subjugate it. And it actually says at the top of the table, these rules of equity shall be supplanted by the civil procedure. No, they're not.
I just want to interject something just to kind of put this into perspective, because you mentioned that the judges actually have holdings in these foster care.
Yes.
And that is, as of this year, the funding for through Social Security is $60 billion.
Oh, I bet it's more than that.
I think it's
and here's a concern my mother brought. Here's a concern my mother brought. We have clearly shown in this case that Title IV was left to local rule. And in the state of Ohio, and specifically in the state of Ohio, it was left to the enforcement by the Supreme Court. In this state, the Supreme Court has said that people who are not attorneys can't bring writs of habeas corpus. That's a crime. That's repugnant to the Constitution. They've also said that you can't even challenge the existence of a license to practice law by arguments within the judiciary itself. We had the motion to strike and to dismiss an argument where we said there's no such thing as a license to practice law, which we brought on appeal. The person bringing the argument to motion and strike it was the administrator, the quote, judge of the Fourth Appellate Court. So you have the judiciary, you have actions of agents within the judiciary itself saying, we're going to dismiss this cause of action which challenges the existence of a license to practice law in our state, and here's the reason why. You don't have a license to practice law. So you can't even argue that's a nullity in law. When you create an impossibility in law and say, well, you can't even argue that a license to practice law exists unless you've accepted one. That right there shows you the coup of the judiciary. They are actively undermining our laws in overt acts of treason and sedition, which is perpetuating the kidnapping of our children by their very friends in the bar who are wearing black robes in these probate courts. This is open war against the American. They are affecting child trafficking openly and willfully in CPS courts, and it was. Can we
let Chris interject? I just want to hear what he has to say.
Yes,
go ahead, Chris.
Well, I mean, and that's exactly 100% true. I mean, to go back through and recite all the people, I am your loss prevention department. Based on all of this history and all of this repetitive circle of never-ending circle of circles, we can definitively show now that there is, yet again, another coup underway. We know it. You know it. You know we know it. And here's what's going to happen. Okay, we're going to end up right back where we started in 1812 if you don't unscrew it. And unfortunately, that means the swampers, whoever the swampers are, but we already know who they are.
Right.
They're going to be given a choice. They're either going to be sent somewhere other than here, or somebody's going to end up taking them out. I mean, that's kind of the long and the short of that. I mean, look at history.
Yeah, the common law mandates that the common law mandates certain penalties in law be affected on these people, and the only problem with that course of action is it's a de facto Congress full of attorneys. They don't have the power to affect the law. They have the power to affect at law under the color of law, which, according to the Judicial Acts of Section 16, when they fail, because they've already failed in this, they've already violated Section 16 of the Judicial Act, when they fail at law to provide equity, that's the only time equity is barred. Now that we can prove that they have, in at-law actions, stolen children against the statute itself and against the law of equity and affected crimes and equity, they're already done. Now, all we have to do is go to Congress and say, okay, you want to settle these claims at law proper, and you want to be the receiver of these corporate instruments that we are going to bring back to the Republic side by these acts of constructive fraud and these unlawful monopolies of the bar unions, or do you want us to sue you and take all of you down? Because we can do that too. And we'll either find out whether there is law in this world or there isn't law in this world, and it's all a farce. But my goal is to bring all of these rogue instruments of a bar union monopoly that are affecting crimes against humanity back into the law, using their own 13th Amendment. We shall peonize and subjugate and enslave these fictions and bring them to the law by claims and equity. And that scares the attorneys, because what that does is it effectively allows us to remove all of our states proper out of the jurisdiction of the Pope. The Pope becomes no longer the banker and the vicar of Christ. He no longer is the king of the world, and the whole argument and coup against the United States is cured. Because when we placed our estates into the trust of that vicar of Christ and the ruling law of the realm with his agents in 1810, if he, after that, affected acts of constructive fraud, he no longer gets to keep it by the law. So they've undone their own trusteeship. These people are not lawfully allowed to be trustees anymore of these defrauded instruments. They shall be removed from the trusteeship of that, and these instruments will be returned to the law. That is what the law mandates. And if Congress doesn't want to act properly, then the United States of American people should get rid of all of them in whatever fashion they see fit, because there is no law then, folks, and it's all a joke, and it's all a ruse, and it's all a fiction to make us look like we're under a lawful construct, and it's all a lie then. But if the law is proper, it should be able to be cured. But Congress, the Congress, has no authority to settle these matters. It doesn't. It's de facto.
Can we let Chris interject here? I'd like to hear what he has to say.
Well, basically, that's one of the reasons why that we can employ, these exact same principles and practices through the corporation, which does exist. So, by doing this through the corporation, we can continue to do business. Okay, we run what's called an end of day. Okay, which basically takes a snapshot of where our business is up until this point. We take a snapshot of it, and we put it in an archive, right? Well, once that snapshot goes into archive, the corporation continue to do its next day's business from there on out. So when you talk about the government shutdown, what's the government shutdown do? That's the end of day. So once we restart the government and reopen our corporation for the next day's business, that's when the new policies come into effect. That's procedures come into effect, et cetera, et cetera, et cetera. As far as how we deal with any bad actions that happened in the previous day, well, those go to their respective departments. Was it an accounting issue? Was it a human resources issue? What was the issue? And we hand it over to those respective departments for their, for them to handle it based on, the way the corporation is set forth. Well, under our corporation, the way we do business is our maxims of law. So the way the best methodology is to employ those maxims of law and start with that. There's our baseline. That's where we go, and then we either go up or we go down. But having a baseline to begin is the proper. That's the only way to basically, effectively do in business exactly what Lotus is talking about doing in law. So when we talk about how these things come together, it always ends up back at the equal side, right? It's either equal or it's not. So in order to make it equal, what we do is we take the actions, the falsehoods. Well, the law punishes a falsehood. That's maximum law, right? So we take all the falsehoods, we couple those suckers up, give those to accounting, and say, here's accountants. You take these and you delegate every falsehood. Here's your criteria: $2,000 per offense, 18 U.S.C. 1621. For every falsehood, that's $2,000 given to the quote unquote victim, right? So we can effectively bring everything back to zero and remove the falsehoods as the way the court wants us to do it. Why? Because we asked them. So that's the way they want to see it done. Take the falsehoods, give them to the accountants, let them divvy up who did what, and distribute that back to the people. Now that's on the business as usual. And that's where we kickstart the economy. So.
Right. Well, actually, the claim that doesn't even there's already a statute that defines the value of the claim. That's 1605C, and it talks about in suits where they're deemed to have operated in constructive fraud that the award judgment cannot exceed the value of the vessel, the cargo, the maritime lien, which means that the value of the sustake is the value of settlement. Now, that's just the value of so if your 14th Amendment sustake v. instrument is worth $88 million, that's what they have to pay to the American public. And then and then again, the Congress doesn't have right to settle this claim. Only does your instruments have the authority that have the standing in law to settle claims. So attorneys don't get to define what they pay us. Title 28 defines it as the value of the cargo. So since they've created an instrument of sustake that has been assigned a value in that 14th Amendment plenipotentiary, sustake v, that is the value that they have to pay us. Then if we can prove constructive fraud, we may aver compensatory and punitive damages to all of the masters of those instruments, which go up into the Queen of England and go up into the Vatican. And all that stuff that they're sitting on that's gold that's not theirs, that's now ours. And all that stuff under the Vatican that they've held from the American people in the world, which is the equity of the world, all of the creations.
We were able to implement loss prevention through the Department of State, not the Department of Justice. We said the Department of Justice is tainted. It's got dirty hands. The Department of State doesn't even have this mechanism, so what we're going to do is we're going to create this mechanism of licensed fiduciaries, right, consisting of myself and various other people who want to volunteer our services, right, to settle these claims on behalf of the Department of State, which is actually a line item on the Corporation of the United States. Okay?
Right, but the values have already been defined. Those values are already defined under Title 28, 1605C. Yeah. Yeah. They've shackled themselves. That's what I'm saying. There's the inherent coup, but then there's a natural course of the evolution of their statutory pillar of law of public contract, which covers diversified claims. And it covers when a vessel, such as a child's body, the vessel of their soul, has been unlawfully seized by these maritime auxiliary claims and suits of admiralty and actions of rem. It says the value that has been assigned to the cargo. That value is the value of the 14th instrument. So we don't even have to work. The law is already there. The value's been defined. It's in 1605C. And in all these suits of crimes against these children and all this human trafficking for victimless crimes in the prison system, those all must be settled according to their statute. And it, like I said, the law is there that shows us how to correct the course and to cure the de facto pillar of statutory law that they're operating in. Like I said, the statutes are great. All the laws are there. There's a few unconstitutional ones within them, but the law's already established. Their statutes are established on how to settle these claims. So, the fact that, and so the power of the people you're talking about, it's really just the imposition of the statutes upon them, on the agents of state that are required to satisfy these settlements as a fiduciary duty. If they don't do it, then the trust can be closed in toto. In fact, the Susticate Trust, the Fed Act, should be closed immediately. It's been proven to be a constructive fraud against the American people. That should be closed. And it's not complicated. They just have to follow the law and law of statute as it's already been defined by the de jure Constitution and the de facto Constitution. It's already there.
Right.
Now, whether they're going to do it,
questions that are not written in law, like for example, hey, can we lie? The answer is no. The court already said no, so don't even ask, right? And when it came to that point, it was at that point that our actual good judges realized that, hey, if we don't let the people unscrew this, those little notes in our pocket that say "In God We Trust," those are not going to be worth a damn thing. We're going to be standing out on the street with nothing. Those robes that we wear, they mean nothing.
Well, they're junk bonds. I mean, by the law, if we choose not to cure them, then everything that the United States Treasury has issued since the Federal Reserve Act, if not before, are junk. They're junk bonds. And so they have a fiduciary duty, even if they are foreign agents operating to resolve bankruptcies, international bankruptcies. They have a fiduciary duty not to collapse the banking structure and the trust structure that the totality of the world runs on. So and if they don't want all the bonds and every Federal Reserve note to become junk, and every treasury, because what people don't understand is the judiciary sells all of its bonds. It affects 3 bonds, at least I've been told it's 5 bonds for every case that's filed, right, under the Full Faith and Credit Act. And everything that has a seal on it, such as a judge's order or a statute, is a fiduciary instrument. It's a suretized instrument. It can be bonded. So not only that, but it makes all of our statutes defunct. Junk. It makes every treasury bond that was issued by the wrapping of judicial instruments junk. It would be an entire, utter collapse of the economies of the world.
If you classify those statutes as what they are, they're bills of attainder, right? What does the law say about bills of attainder? Well, those can't even exist. Right?
Well, and also the conveyance of blood debt. These are all repugnant constructs.
Bye.
I mean, they don't have, they're either going to have to fail in their fiduciary duty or they're going to have to correct the course of the coup. If they fail in their fiduciary duty, their acts would be nullities anyway, because in repository trust law, and this is where repository trust law is the prevailing law we're dealing in here. Under repository trust law, everyone is deemed foreign to each other, particularly nations. The United States of America is foreign to the states themselves. The states are foreign to each other, and they are foreign to the collective compact of the United States in the United States Corporation. We're all foreign to each other. The only reason we are compelled in any law to comply with the demands of the states versus the United States versus the American people is as a fiduciary duty. Repository trust law will tell you that you are not obligated to follow the law. Nations are not obligated by any construct to agree to the laws of other nations. That means that the state, Ohio, does not have to comply with the laws brought forth in the state of Michigan's legislature. Okay, the territory Michigan being run by, having its seat of government run by a corporation. They don't have to, but they do by agreement of the compact of the federal instrument, the de jure Constitution. But it's based on fiduciary duty. So in the failing, if they are ens legis instruments, meaning if they are instruments of law that create a seat of power, such as a judge, such as a senator, such as a POTUS, all these things, these are seats. Men occupy them, and men are transient in them, and women, but the seats of ens legis statutory and lawful requirements sit there in perpetuity. Okay? When those men and women within those seats,
that seat defined in law is called an inherited emolument, right?
Right.
That's why every state's constitution does refer to these seats as inherited emolument.
Right.
There's your answer.
Right. And so when the men and women in them, as transient occupiers of seats of state, don't comply with the rules and the statutes and the laws of those instruments, those acts are nullities. Okay, in law.
And so this is why I wanted to bring you guys together, because Chris has his emollients, and you have your fourth crown. So I thought somehow in my mind.
No, absolutely. It's a synergy. You got a synergy going on here, because if he's been told, well, you need to go to Congress and define unjust enrichment, he says, no, I don't. It was defined in 1810. And there goes the game. There goes the game, because then it clearly shows that what you have in all these acts, in that we are not supposed to be subject to these magisterial civil authorities, is you have an encroachment of our foreign state immunity, which we were given when we started this country. So, and every one of those encroachments by the presumptive trustees of the prevailing realm's law, Roman civil law, that are encroachments upon our inherited emoluments. Our cession, which means the conveyance of that which we are owed by law to inherit, which is what they're cooing. They're cooing the instruments that by the maxim of cession, the lawful conveyance through inheritance of the people. That's what they're trying to interfere with, and that's all we have to do. So he has a great case, and we can like I said, all things being divine in their nature, all things will come together. And the course that have been brought, these cases that are being brought by people, because I'm in the same boat you are. I mean, I started with doing what I was doing because I said, I know what's going on, and my name is not going to be associated with these crimes against humanity and these acts of treason and sedition that are undermining my republic rights and the inheritance of my family. My family helped create this republic. They came here in the 1600s. I assure you, my family did not start this continent, the governance of this continent, and because there's some histories that have been obfuscated, the Tona being one, but we started this to be independent. That's why it's the new world and not the old world. We wanted to create a system of law where false men and women, in that men and women are inherently malfeasant in their nature, cannot, as a singular instrument or an instrument of state, run over and tyrannize the greater body of people. That's the American construct. So it's curing that. We had to set this course. We had to allow their pillar of de facto statutes at law, law as statute, to evolve till it met ours, so that when we could cure their falsehoods of their argument with both, bringing them both together, because the fraudulent arguments are being made by men, not by the instruments of state that we.
Correct. Right. So what I said is we protect the integrity of the inherited.
Wait, Lotus. Let Chris interject here. I'm sorry, Chris.
Right. So what I've said is, and this is what got got the attention of the federal court. We want to protect the integrity of the inherited emolument. Judge, tell us how you want us to go about doing this. Right? That was the first three cases I constructed in my monopoly argument. And they said, okay, here, we're going to give you a practice, bring it forth to us, right? You can either do it in pleadings or you can do it in reports or whatever you want to do. We know what you're talking about is stuff that's already happened, okay? So that's why I generate reports as well as pleadings, right? Because the reports are basically, look, this crap's already happened. The Declaration of Independence says, let these facts be displayed before a candid world. Okay, so here's the facts, right? And where does the governance come from of these facts? We already know the answer to that. Okay? All we need to do is apply it. What's the application mechanism? We don't even need to ask the court. We need fiduciaries to do that. So that's exactly what Lotus is saying is exactly what I've already built through the Florida Department of State. And the Florida part is pissed. So, I really don't care. But because we've given them an out to protect the inherited emolument from, what do they call it? The conversation now is called Gorgeous George. He was an old snake oil salesman from, back in the Old West. And he got his nickname Gorgeous George from, basically his notoriety of he could smell, snake oil in just about anybody. Well, that's exactly what these bar members are. They're snake oil salesmen. So
absolutely,
we said, okay, let's follow the premise of the snake oil salesman, and we'll go about it from that way. So we said, okay, we already know this crap happened, but we got to agree to disagree at some point in time. And the thing we have to protect is the seat, right? That's the goal. That's what we want to protect. What do we want? What are we going to do to do that?
For the continuation and preservation of the republic and its instruments. We're not wanting to. You're not wanting to tear it up. You're wanting to rebring it. You're wanting to bring all the instruments of those inherent emoluments back into the crown of law, and that's what the goal should be. And that should happen with with your course.
Right. And see, what we've done is, in order to do that, that's a process. The process is all of the falsehoods need to be dealt with first. And the federal court agrees with that. That was the logic. The federal court agreed with it. Said, here, handle your falsehoods. Deal with those. Deal with those through the independent mechanism you've created, through the Department of State. Use your licensed fiduciaries, right? Myself and our various other CPAs and other fiduciaries who know and understand what this is. You bring forth your reports and give us a path to follow. If you give us a path to follow, we'll follow it.
Yeah, it's all there in the law.
Exactly what I've done is I constructed this new case in the in my federal court here, saying, okay, U.S. Congress, okay, you're now my client. I'm going to show you how to do this through the fiduciary mechanism.
Yep.
And that's exactly what we're doing. And I've brought Florida Congress and the Ohio Congress into this meeting room called the federal court and said, okay, here's what's already happened. You know it, I know it. Here's how we're going to unscrew it, and it's already written, so all you got to do is do it. And now they're saying, well, crap, that means we're all liable. Who's going to jail? And we don't care about that at this point. What we care about is protecting the inherited emolument. Why? Because the federal courts said so. The federal judges have said so. That's the significance of also what just happened in Hillary Clinton's home state with their Supreme Court saying, no, you can't enact legislation that's repugnant to our form of government. So even the good federal judges are now starting to understand what the fiduciary mechanism is.
They've been lied to. They've been lied to as to what the true law is. They've been lied to as much as all of us. Not all. I mean, as I say all the time, if you listen to anything I say, you know this, Amelia. not everybody's a criminal here. But if after we bring the law to them, they continue to act in obstructions and in warrant against the United States, then they are criminals. That's when their fiduciary is breached. When you bring the law to them, when we bring the law to them, because they are admittedly not learned in the law under Title 28. They have admitted we do not know the law. That's in Title 28, that declaration. Once we bring the fact and law to their bar, though, if they then continue to operate unlawfully, that's when it becomes a tort. And that's when it becomes a criminal conscientious act. So he's right about that, because I do not believe that very many people
through my amicus a declaration of no confidence in the bar. So I started that way back in my original monopoly case. I said, well, instead of filing an answer, let me go ahead and file an amicus in on this, and I'm going to make my declaration right here and right now. So
absolutely. Yeah. Amicuses are very powerful. I do believe we're in a very good place in our history because the law is being brought forth, and that's the goal of the cooing attorneys. Attorneys are doing things because they're just told to do it, but unfortunately, ignorance of the law is no excuse. Okay, and so even though they admit they're not learned in the law, that does not obfuscate their obligations in law. They put themselves out there as attorneys at law, as not learned in the law, to the greater body of the American people. So that then in this private the statutes and deep in Title 28 say we're not learned in the law, we're not required to be learned in the law. That in itself is a constructive fraud. So that the bar unions themselves need to be broke up. They need to be declared unconstitutional. They are criminal enterprises. They violate the law. And I don't care if they're foreign agents. I don't care if they're under treaty to operate here as a union. They cannot operate on our land as a union.
Go ahead, Chris.
Right. Well, this is the reason why I constructed this the way I did. And I said, look, what we need to do is these bar cards of this foreign agency, we need to take those and register those through the states. Okay? And make these attorneys learn the law, right? Here's what your law says. You're practicing here in this state. Here's what your law says. This is what you need to be doing. And if you want to practice, you can practice whatever the hell you want to practice. We don't care. But you're going to do it in accordance with the law, not with what your old bar rules say. Take the opportunity, quit puking off the balcony, and go graduate college and go to work. So far, even the states are like, how the hell did we miss this? So all we had to do was go back to the beginning. Let's see here. Provide new guards for our future security. Awesome. We can definitely do that. So that's what we did. We provided new guards for our future security. So,
but allowing these bar unions to continue.
Report to Congress. That's why in the table of authorities, the Declaration of Independence is the governing authority of that report.
Right? Because it's a compact. It's an agreement.
Exactly. Right.
And those compacts are indelible. They are not transmutable. They can't be amended. They are facts of law. And the attempt to undermine those compacts is the coup. Just like with California, this AG, the Attorney General, they're saying he's going to basically attack and prosecute people who are in compliance with the federal mandates. He has no authority or standing in the law to do that. That's an act of treason and sedition, warrant against the United States. That type of carpetbagging and the monopolistic practices of these bar unions, whose inherent culture has been for the last 200 years to steal from the American people and to undermine and defraud our instruments, it must stop immediately. And people who have participated openly and willfully in crimes need to be prosecuted and put in jail. And that's the first thing that does need to happen. Those ranks need cleared. There needs to be, if they're sitting here putting people who are affecting victimless crimes and trafficking them for money in the prison industrial complex for crimes not of of an insignificant nature that are victimless, while these bar union members are affecting crimes against humanity and violations of the law of nations and treaties and such.
Right.
They need to be dealt with effectively by the military, because they're treating under the military, under, I believe, Title 8, I think it is. I can pull it out. But if the military's not going to do it, we'll do it, and they won't like the way we do it because there'll be a whole bunch of hemp ropes and millstones sitting on boats. So, they can clean them, but it needs the course of the law needs to be corrected, and this coup needs to be routed out, and needs to be routed out as quickly and as efficiently as possible because we have children that are being kidnapped and tortured and trafficked and probably murdered and a lot of other things. And there are agents within all the agencies of state that are conspiring to affect such things, just as they conspired to affect a coup of the election against Trump. It is the action, you will know them by their deeds. But unfortunately, until they clean house with these cooing attorneys that are complicit in these crimes, we're not going to have a lawful government, and we'll continue to be a lawless nation, which I think the attorneys themselves, when you bring the law to these attorneys that are righteous men and women, they are just as offended as a regular American person, because they didn't go into being an attorney to affect crimes against humanity surreptitiously. They didn't.
That's not what I signed up for. And I'm showing them, look, you want to unscrew this? I can show you how to unscrew this.
And we're the ones that have to tell them.
Kick that son of a bitch right back out to sea where it came from.
Mm-hmm.
Right, exactly. That's why the thing with the Lotus, you notice the new Lotus thing, they're wanting to expand the definitions of waterways in the United States. Those are unlawful encroachments of, they want to bring water law, admiralty law into every culvert of a farm. That is an unlawful encroachment of the admiralty law. It's criminal. That's a coup of the Republic laws, trying to overlay admiralty law even into the culverts of farms and the drainage trenches of farms, your gutters on your house. These are repugnant constructs. It was an appropriate ruling by the Supreme Court to say it belongs in the district courts, but the problem with the district courts, our territorial courts, is they are run by the prevailing bar union monopoly, and they are not going to get fair hearings. There's not going to be any equity at those bars, because the bar union wants to perpetuate an unlawful encroachment of admiralty law, because they're barred from the law of equity and law. They are only left with admiralty and maritime. So their coup of the law is through the admiralty suits. So if you don't clean that house, because the district courts pursuant to the Judicial Act are the courts where you bring those claims pursuant to the Judicial Act, and they also have the right in suits of foreign bills of equity. So those are the proper courts, but if those courts are going to be monopolized by cooing bar unions that are affecting acts of RICO and treason and coup, then those admiralty courts are not going to enforce law of equity.
I'll tell you guys, I certainly feel vindicated, because for years, people were calling me crazy because I was saying, look, this is fraud on the courts. This is human trafficking. And nobody wanted to believe. Human trafficking has nothing to do with CPS. People.
How could anyone of logic and reason say such a ridiculous thing? It's all about trafficking of babies.
It's a very real threat. And, the next real threat on the horizon is the legalization of the child trafficking and the pedophilia. And, they're going to try and legalize these crimes and push for that. So,
those are against the law of equity. They can't do it. Again, you cannot make illegal what is not lawful.
What I would love to do is, exchange your information, your contact information with Chris, if that's all right with you.
Oh, absolutely. Absolutely. I would love to help him in his cause. I think the two are kind of synergy in this. He has the clearinghouse. He's developing the clearinghouse rules for these banking platforms to correct the bar and the ledger.
Right.
And if he's doing that side, we're doing the law side and affirming the law and the violations of the trusts and the international crimes, and which would require them to clear these proper. And again, they do not have the standing in law to do it. Only the American people in a republic de jure construct have the right, and just like we have no right, that's why I'm referring to the 1605C, because that's right there. Everyone who's had their trust violated, then move that value across the ledger to our side in the value of the vessel and cargoed instrument, the vessel of the soul. If my vessel of my soul has been valued at $86 million and I was unlawfully put in prison and conveyed in human trafficking, the Pope loses that much money on the ledger. And then after we get to that, if they still have any money left, which I don't think they will, then we'll get the rest of it through compensatory and punitive for egregious crimes against humanity. The function of our law and the purpose of our crown was to remove the power of false vicars of Christ and false Elohims from tyrannizing the people and subjugating the people of the world to vassaldom and the feudal constructs that existed before it. That's our manifest destiny. That's what we're doing.
Wow.
And that's what
so that's the new objectives, guys. I gotta wrap it up. But
no, amazing show. I'm glad you introduced us. He is definitely on the right track as far as setting up. That it's our job. We are obligated to tell them how to settle these claims. But I'm going to tell you, the value's already been set. It's in 1605C. It's the value of the vessel. Every one of us has been valued as a vessel of our soul. Our bodies have been valued. So the value of the claims brought in just standard curing of it, just a simple claim, it says it can never be more than the value. That doesn't mean if you prove constructive fraud, you can't add compensatory and punitive. So they're in debt to the tune of the value of each one of our 14th Amendment Susta KV instruments. That's the bar must be reversed in the ledger corrected for each one of those crimes. That's the law.
Amen.
That's their law.
So, Chris, I'm going to let you wrap it up. Where you want to share anywhere people can find your emollient?
Go to Facebook and find my group page under Amber and Stephen. You can pull up any one of my files. Basically, my mechanism is so simplistic. It's roughly out of the 485 pages, the entire thing can be defined in about 20 pages of it. So it takes you all about maybe 10 minutes to read it, and it's so simple it's scary. So that's the great part about it. And the more complicated they try to make it, the easier the unscrewing mechanism becomes. So the name of that group is Amber and Stephen. That's my kids' names.
Okay.
So go ahead, and anybody who's in there, it's a public group. You can just ask to join, and anybody can let you join. Go into the files tab, and you'll meet up with some of the best minds that I've worked with. And I also do a show on Monday and Wednesday nights with Kurt Pendergrass, where what we do is we talk about the law. And the last night's show, I did a comparison and contrast between the scales of justice. So when you walk into court, you know what scale you're looking at. So,
and that's a great show, by the way, folks. And you can I've been posting it in the Porthole to Justice, a link to the show, so you can see it there. Yeah, thanks so much for coming on.
Sounds like we have a plan. Sounds like we have a plan.
Yeah, I look forward to talking to you more, Lotus. I really do.
I look forward to pairing our two, coming from both sides, because they can't settle this, people. They don't have the power to affect these settlements. No. It is incumbent upon us to do it. That's why this has been allowed to be protracted for so long, is that our ability to come forth and tell them how to settle it has been stifled and stymied by acts of treason, sedition, and tyranny, and all that stuff with people being targeted. So I'll definitely look forward to working with you on that, because you're already there. I mean, you just have to walk in with what they've mandated you to do and say, well, here's the definition of unjust enrichment we're going to work with now. And this is where in Title 28 it tells you how to settle these claims. And that's under the diversified citizenship clauses in Chapter 97 for foreign state immunity. So there's that. I think we're good to go. I think that I know it will all come together, because that's just the divinity of things. But very glad to have had a chance to speak with you.
Let's do it, guys. Let's do it. Amen.
Yeah. Thank you, Amelia.
Save these kids.
Yeah, let's do it. All right, guys. This has been another episode of Porthole to Justice Off the Cuff. I'm going to call both of you back, Lotus and Chris, and exchange contact information. You can subscribe to my show on Spreaker.com, and if you want to donate to the fight, you need a tax write-off, and you want to donate to the fight against human trafficking, you can go to human2020.com, and you can push the donate or contact button there, and you can get some of those really great tax write-offs. Or if you want to support the content on the Porthole to Justice, you can go to my Facebook page. I have a PayPal, and and thanks, guys, for tuning in. Thanks, D. Cook, T. Glendinning, and hey, Jedi. All right, guys, it's been fun while it lasted. Okay, bye-bye.
All right,
Bye-bye.
now.
God bless.
You too.